Mr. Scheisfield.
Thank you.
Thank you, sir. First of all, we provided a copy of the draft mods that reflected, I believe, Mr. Manette's evidence specifically with respect to the wording proposed for the stratification policy. I think that's where we're at. Is that correct, Mr. Manette?
I believe so.
What I do with my version?
Now? That's good? Oh, okay. I have to write instructions for each time I do it.
So, okay, just to be clear, we had provided a copy of the document from which Mr. Manette gave his opinion on the wording of a proposed stratification policy. And I believe we now have that up on screen.
Yes. So I believe when we left off, I had read out my proposed wording change. However, there is also a suggestion that we renumber the policy within the framework of the document. And my suggestion is to move that to renumber the policy as 12.5.6 bracket 2.
And that would move it to what section of the proposed plan?
Just pull that up.
So just to move forward.
That would be under the site plan control section. And that would be, since it would be under implementation.
Thank you. And so your recommendation to the tribunal is twofold?
Correct. There would be the change to the wording to, in effect, slim it down and then put it under the implementation section. And the suggestion is to put it in the site plan control section, since that's where it would be implemented.
Now, in the event that somebody might think that this document is some full response or redrafting of all of Exhibit 35, can you just comment on that? Like,
well, when we received Exhibit 35, I looked at it on the face of it, of what it's changing. And this has to, in effect, these proposed changes here have to be read in conjunction with the modifications that we proposed earlier to the plan, which is in Exhibit 33, tab 19. So this only addresses these proposed changes as we receive them.
and
So this does not represent the only modifications that we would want to make to the plan part 2.
And under section 12.5, implementate, look on screen, please. Under section 12.5, stopped here, you see that?
Yes.
Just what's that about?
In effect, we did not go any further to deal with modifications because in effect, until the rest of the policy changes are made, you really wouldn't know what you were going to be implementing. So it didn't make sense to make changes at that point. And in fact, my position would be the same with respect to the zoning bylaw. If there are going to be sufficient, or let's say significant modifications to the part 2 plan, the proposed secondary plan, it would be premature to be looking at finalizing the implementation policies that relate to those. And also it would be premature to deal with the zoning bylaw that implements those. So most of the emphasis that I put in and my reviewing of the plan was to deal with the substance of the policies and then leave the implementation and the zoning bylaw in effect implementation to a later time once we have the final form of the actual secondary plan policy.
I'm going to come back to this in a moment. Did somebody want this marked? Should we have this marked? Can we have this marked?
Mr. Chair, I have no objection to marking the document since it reflects the witness's opinion evidence. I would note that there's a few places in this document, or at least one place, where there's a series of questions that are posed.
Yeah, we're going to come to
presumably by Mr. Manette. And there are also a number of instances where there are proposed mods that in our submission relate to phase 2 matters, but we can deal with those as and when we come to them.
So this is number 57 then, is it? And how do I describe it?
part of NEC proposed mods.
No, can I suggest that if you look in the blue, NEC proposed mods as of July 20th, 2020 would be the appropriate reference. So this was exhibit 50, what? 57, thank you.
Now, I'm just going to pull that off the screen, and Mr. Manette reminded me that I'd like to go to exhibit 28 for a moment. Exhibit 28. And with respect to exhibit 28, the photographs, Mr. Manette, what is it that you wanted to advise the tribunal?
Chairs, I think it's appropriate because this has been referenced by others, that would be appropriate that it be proven by me because it's an exhibit that hasn't been proven yet. And just for the record, to advise that I am the author of the document and what it contains are aerial photos, and those are the ones that have been referenced to date, along with other photographs. And I guess there would be part of that that would be considered phase 2. So I don't plan to address those, but it's contained within the document. But just suffice it to say that these are current as much as they were at the time the hearing started, aerial photos of the KDA area from a number of different directions. And I'm happy to see that they have been of some use to the board prior to my partaking in the exercise, because I know they've been referred to on a number of occasions by others who have given evidence. And it's always been my intention when I provide aerial photos to the tribunal, I'm providing them for that purpose. And I have no problem if they're used by other parties because it only assists the board for information purposes. And I just wanted to make sure that we had that on the record that I took them, and the dates of the air photos were June 22nd, 2020, which is pretty current with respect to any information you might be able to have before you.
And just with respect to some of the photos on photo 1, first of all, Mr. Manette, have you been following these proceedings?
Yes, to, I just wanted to make sure that the board was hearing the evidence.
Oh,
Something specific you were going to ask about, because we don't have a copy in front of us. Should we have? We'll look it up. We'll look it up. I just want to know where you're going with it.
and can you just very quickly, just by reference to some of the photographs, walk us through what it is you photographed in less than 1 minute?
Okay. Should I go ahead? Okay. 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 Photograph 1 is an overview of the entire KDA area looking from the south north along Yonge Street to effectively identify the current development in the KDA, including the new construction, and most specifically to show the construction of the BRT along Yonge Street. And so that gives an outline of the existing situation of existing development in greenfield areas and the surrounding community as well. So that's an overview, and I understand that's been useful. So I'm glad to see that. And then going forward, I've taken pictures of the northeast quadrant, more specifically from all 4 directions, north, south, east, west. And that's to show the interrelationship between existing development, the new infrastructure that's being put in place with respect to the BRT line. It also illustrates very clearly where the bus transit station is on the property to the south. And it also shows the adjacent residential neighborhood areas, as well as the proposed development areas for some of the other property owners taking part in the hearing. And then we have some surface pictures that were taken on June 25th. And this also, those are photographs starting on page 6. They show the existing construction up close with respect to the BRT line and the relationship between the BRT line, the infrastructure on Yonge Street, and also the adjacent right-of-way and how it's being handled through the construction. So that's the purpose just in a nutshell.
And you see the photo on the screen?
Yes.
Okay. And what is your understanding with respect to the construction of the BRT in this location here?
Okay, and I believe that's photograph on page 5. That's an NEC site taken from the west on June 22nd. So what that shows is the Naughton Road where it's closed. You can see the barrier right in the foreground. And then we have where that comes out, there's a blockage. So that would now become right in, right out only for that short period. And then across the road, we have the access to the NEC site, which is now closed, and it's now closed off for full access movements, and it's a right in, right out only as well. And you can see the infrastructure is right in front of that entranceway, so that would block any crossing over to the west side of Yonge Street. Just for the purposes of illustration, that also shows the drainage channel on the north side of the property line, which is the edge of the roadway, which also forms the boundary of the KDA.
Is that?
So that drainage ditch is known as block 32, and I think you've seen reference to that already. That is a separation between the northern property boundary of the next site, which is the boundary of the KDA, and the neighborhood to the north. So the channel is within the neighborhood to the north by location, but it forms its own channel as it goes from underneath Yonge Street towards the east to to Yorkland.
So just for the tribunal's information, the limit of the KDA as proposed in this secondary plan follows what?
It basically follows the driveway, because the north boundary of the driveway drops off into the drainage channel where there's a fence. And then as you can see, the building, one of the commercial buildings is right at the edge of the property line, and it would be just south of the north boundary of the KDA.
Okay. And planning question, can you confirm for the tribunal what the Part 1 land use designation is for the lands that you were just describing?
The lands within the boundary of the property are designated KDA.
And you see where I am over here?
Yes.
Okay, we call this 70 Bernard.
correct.
And does that boundary continue?
It continues along, as I understand it, the north boundary of that property, which is where the approval is for the new building to be built on that property in that north parking lot area.
Okay. And
Just ask, those are the retirement lands? I'm getting lost.
Yes,
Yeah.
the property to the east. And as you can see, the entranceway between the apartment building and the commercial building on the NEC site is a driveway. That driveway is 100% on the NEC property, and there's an easement agreement for access to the seniors apartment property.
is this the area that you're talking about?
Yes, that driveway. And so up where the entrance goes into the parking lot for the retirement residence, that's where the property boundary would be. It goes on an angle.
Okay. 1 second. Can I take you to exhibit 33? Tab 22. I think it's 20.
We have a 22A and a 22B.
Yeah, I think it's 22B. And we see a deed.
Yes.
Okay. And I just, by the way, what is this document?
This is a notice of agreement through land titles.
Yeah, but what is the document?
Uh, want to make sure that I believe this is the easement agreement for the allowing the access.
Take a look at the document
Yes.
again. Okay. Doesn't matter. Please go to page 62. If you look at the top of the pages, they're numbered. I think it says there's like 119 pages.
Okay, I have that.
And you there?
Yes.
Okay. And do you see on the document block 32?
Sorry, Mr. Chair, before we go further, the witness has not identified this document. He said he thought it was an easement agreement. Mr. Streisfield, I think, was trying to correct him. So we haven't actually identified this document. I don't think it's appropriate to be referring to a portion of it when we don't exactly know what it is and the witness could not identify it.
Can you go to page 3 of the document?
Oh, so, sorry, this is the subdivision agreement for Bernard Homes and Southfield Investments, and then also York Region Board and York Region Catholic Board.
Thank you. And now can you go to page 62? And I think that page, you may have to turn, it's schedule A.1 to the agreement. You see that?
Okay, I'm trying to find it because after page 61, there are the drawings, but they don't have numbers
Just,
on.
we're going to the drawings.
Yes,
Yes,
Okay.
I think it's hard to see the page numbers. Do you see, right?
right. The
Okay,
question-
do you see Bernard Avenue? Only on the document. Just look at the document.
I'm looking, are you talking about one of the plans?
Yes, we're only looking at the plan. So
Okay, but I have to go to which plan? It's not, because it's not on the first plan. So,
this,
I want to find the right plan.
You are at the right page.
Okay. Oh, okay. It's upside down, that's why.
thank you.
Okay, it was upside down in the book. That's why I couldn't read it.
So we're at that page. So we're looking at a portion of the subdivision agreement, and you referred to something. We were looking at a portion of the subdivision agreement.
Correct. So if
All
we
right, by the
turn
way, are you familiar with subdivision agreements?
yes.
Oh, good. You may have to turn the page this way.
Upside, yes.
Yes.
No, I have,
Okay.
so if I hold it completely upside down, it's readable because north is always at the top for planning purposes.
Okay. So
This will be helpful.
thank you. So do you see the reference block 32?
Yes.
Okay.
So if you look at this Bernard, this is at the top part of the drawing. You have Bernard Avenue going over to Yorkland, and then on an angle which forms the property boundary for the subject site, we have a block 32, and then on the east side of Yorkland, it's block 33.
And just to be clear, going back to your visual evidence where you referred to the block.
So if you zoom back out, that's page 5. So block 32 would be the area that has the trees in it, which is between the commercial property and the residential property to the north.
Thank you. Anything else you want to say about your photographs?
No.
Okay.
I think they're self-explanatory. I've got 1,000 words for each picture.
Well, I'm sorry, what was that all about? Sorry.
No, I asked him if he had any further comments about his photographs.
Just confused as to, are you just identifying the block area or the location of the block? Is that the whole purpose of that exercise?
Yes,
Okay.
yes. He gave evidence that there was a block. So we wanted to tie it down to a legal document that there really was a block. And we related it back to the photograph so you would know where it was. Okay. You made reference to, in this photograph, to, what are we looking at right here?
That is Naughton Drive where there is a closure and you see the barrier. So it only provides access into the commercial property from Yonge Street, but not into the subdivision to the west.
And your understanding from this secondary plan is what in relation to this barricade?
Well, long-term, the intention is to close the access to Yonge Street. And what happens with the remainder of Naughton Drive, it would be subject to whatever redevelopment occurs.
Okay. And do you see where my cursor is right now?
Yes.
Okay. And I'm drawing a circle.
Yes.
And what is your understanding as to what this secondary plan may contemplate in the roadway only?
Okay. That is where there is supposed to be a signalized intersection.
I'm sorry, Mr. Manette, when you said supposed to be, what do you mean?
Well, if we go to Schedule 4,
Yes.
that's
Right,
identified as
it's right in front of you. The map right in front of you. Yeah.
I understand now. Sorry, I didn't mean to divert you.
right. Okay, that's the one potential signalized intersection is the term.
Now, if we can just go back to your witness statement. And perhaps you can sort of pick up, I guess, from page 4, that seems to not have any yellow on it.
Okay.
There's no yellow on paragraph 14. Can you address that, please?
Okay. So in paragraph 14, Did I hear something? Oh, maybe that was the next.
This document doesn't have page numbers. Perhaps you could identify.
On the bottom?
They're on the bottom.
Oh, this one, the witness statement.
Yeah, I'm looking what, as I understand it, to be the redacted witness statement that I'm to use.
Yes,
Okay, so I'm in paragraph 14.
Yes.
And so I'm referencing the chronology of events and talking about the council meetings. And I've indicated that I think the YBI motion indicated a chronology of events that I agreed with. And I guess it's been determined that we were talking about the May 13th and May 14th council resolutions. And I've opined that it is clear the vote taken by council on May 14th was not made in open session, as was the case for May 13th. So I participated and observed the May 13th, and there was discussion related to the proposed
Mr.
plan.
Chair, I'm sorry to interrupt the witness again. The
Again.
tribunal has already made a ruling that
Ruling.
nothing that took place on May 13th is relevant to these proceedings.
yep,
But
So I'm trying to save everyone a lot of time on
It
this.
seems to
Right.
be an
I
effort
know.
to get back to the public documents in May 13th.
we
and
appreciate
have ruled
it. It hasn't
against
been
those.
redacted.
thank you. Well,
But
that's
let's go on
okay.
further.
Okay, yeah, it wasn't
Nope,
redacted. Okay, so,
Nope.
okay.
So just before we move forward, as a land use planner, how do you consider the requirements of section 2.1 of the Planning Act? What information was before, do you know what information was before council on May 14th?
No,
Mr. Chair,
Okay.
we've already stipulated
Yeah.
that
Go on.
May 14th was in closed session, so the
Yes.
city is not relying on any material that may have been before council at that meeting.
And if it's closed, he wouldn't. No,
Okay, and paragraph 15.
okay, well, I think I've just described that my experience in and understanding and familiar with the area. I've been on the site numerous times. As you can see, I've taken site and aerial photos, and I think we've already introduced those now formally, so they're in play.
Okay, now we're going to the BRT, paragraph 16.
Right. So the reference, when I say illustrated in the plan below, that's illustrated on the following page, and we put a photograph of an aerial photo with the overlay of that on the in there. And so, just in summary, my opinion on what is shown here is that the BRT system is designed and currently being constructed directs all pedestrian traffic to the intersection of Yonge and Bernard for access to the BRT platforms. And that also directs them to the bus terminal on the southeast quadrant. And that's further detailed in, and you've already heard evidence from Lee Consulting with respect to that. So as we can see from the diagram, the actual platforms are accessible from the corner of Bernard, actually that four-way intersection. So any pedestrians that would be either currently in the area or in the future development in the area have full access to the bus platforms and the Bernard terminal, the bus terminal, through that intersection. And with sufficient walking distance, there's a short walking distance pretty well within the entire area to access that those infrastructure for transit.
And sorry.
Go ahead.
With respect to the second sentence in paragraph 16, can you elaborate on that, please?
So in my opinion, a break in the BRT system would be contrary to provincial policy.
What specifically?
In dealing with, well, I don't know whether they want to go to the provincial policy, but generally speaking.
Just deal with the generality, so we got to move on.
Okay.
Please, if you don't mind.
If you have infrastructure in place and there is no study that identifies that you would need to change a situation, and this is just a general understanding, then the situation, unless there was a study that identified a need to change that, then there would be no reason to do so. My understanding is there hasn't been any study at the regional level or local level that would indicate support for a break in the infrastructure.
And how does that relate, if at all, to this symbol that is proposed in that location of a signal? How does this opinion relate to what's proposed to be put on the plan in terms of this mark called potential signal?
Well, in my opinion, I think it's appropriate to remove that symbol from the schedule because there hasn't been any justification for putting it there other than suggesting sometime, and now based on evidence I've heard and that you've heard, it may be well down the long term. So there would be no reason to put it into place in this particular secondary plan, because looking at the time horizon we've heard where this might come into play, there would be a review of this plan should it be approved, at least within 5 or 10 years in any case. And at that time, if there was a reason to do so, then it may be appropriate to put it in at that time. But based on the
Chairman,
time,
it's Ms. Moran. I need to object at this stage because in Exhibit 56A, if you turn with me to page 21 under issue 20, the reference, the evidence with respect to a reference on the schedules to the secondary plan to future signals should be removed is actually redacted. It's not part of this phase of the hearing. That's an issue that's specific to the NEC quadrant only. And so I'm going to ask the tribunal to direct Mr. Streisfield and the witness to move on out of this because this is a phase 2 issue.
Next question.
Let's follow your witness statement and hopefully avoid any of the yellow.
Sorry, Mr. Streisfield, if I could interrupt for a quick second. Can you please remove any papers from the front of the camera when you were speaking? Thank you.
Thank you. Sorry about that. Paragraph 18.
okay. Now, the part that is not redacted is just a factual statement identifying the context of within the overall plan. And I'm indicating the lands are highly urbanized and are on full municipal services. And when I refer to private service, and I'm not referring to septic tanks, I'm referring to the internal services to the site, connect to the public municipal services within the Bernard right-of-way. So that's just to identify, and that goes to a general comment I want to make with respect to the background documentation used in preparation of the secondary plan. And I have made comments to the city through my evidence and my submissions that the concern I have is that there was not a fulsome analysis of opportunities and constraints within the whole KDA as a starting point when they did their initial work for preparing the policy document. And that, in my opinion, should have included some understanding or reference to the current situation and the differences of the area with respect to areas that were fully developed and the nature of the development and areas that were in effect greenfields without having those same constraints, because the policies that would be carried forward to implement long-term planning within the KDA should understand that there are those differences, which may affect both the potential development on some of those sites and also the redevelopment of some of those sites, which would have different requirements and constraints and or opportunities. So as an example, there may be opportunities where there is existing development.
So, Mr. Chair, again, my apologies. We're now talking about evidence about the alleged deficiencies in identifying opportunities and constraints on the NEC site.
No,
All in aid of a different development concept for the NEC site. If my friend's witness is purporting to limit his evidence to deficiencies in identifying opportunities and constraints on other quadrants, overall, from an overall standpoint, that's fine. But to the extent he's venturing into evidence with respect to deficiencies in the process as it relates to the NEC site, that's a phase 2 matter.
Well,
I think he's
I-
remained general so
General.
far, and perhaps caution can be kept in mind for him going ahead.
And I'm fully aware of that. And I tried to make sure that I did that. And I'm talking about a big picture analysis at the front
Okay.
end of the, I seem to have an echo. Yeah. So I'm talking about an overview analysis at the start of any planning process. The first thing you always would do is, and I've done this because I've done secondary plans for the city. Opportunities and constraints.
Okay,
Okay.
move on. My colleague, and I agree with her on that particular comment about the overall so far.
Okay.
And
I'm getting an echo here. Okay.
And as a consequence of this opportunities and constraints, how does that inform your opinion with respect to the plan as currently proffered to this tribunal?
Well, as an example, I don't think the plan takes advantage of some of the opportunities, and it also doesn't recognize where there may be some constraints on lands within the KDA and in total. And that's with respect to the potential for intensification and urbanization. And in fact, there's actually no reference to those matters in the plan. It just goes forward and presents a plan without any background direction coming from any opportunities and constraints that might lead to the formation of the policies.
And you understand that some of the lands in this KDA are greenfield?
Yes.
Okay, and how does that relate to your opinion?
Well, where there's a greenfield opportunity, they would have fewer constraints. And also you would expect it to be done in a different form through draft plans of subdivision. Where you have development already occurring, there may not be any need for a draft plan of subdivision. It would just be a redevelopment on a site plan basis. And in fact, blocks of development have already been created.
Paragraph 20.
Okay, that's another general comment within the secondary plan. And that's looking at the creation of a complete community. So when you have an opportunity within the secondary plan, there should be some kind of vision that suggests what kind of community that we are trying to create. And in this case, where you have a community that has some existing development and some new greenfield development, there should be some vision that identifies how that complete community can be created. There's reference to terminology in the plan that talks about enhancing the existing development, but there's no indication of what the development is you're trying to enhance and how you would do that. It's just a statement without any substance. So we've suggested there should be a variety of housing options that include rental housing. Car-free households should promote live-work units and opportunities, as well as dwelling units that accommodate aging in place. Those are principles of planning that are current. And I think based on what's happened in the last 6 months, the concept of aging in place becomes even more important. And certainly there's no indication that that was contemplated in this plan. And the promoting live-work units has become more important. And even though this was prepared in effect prior to a lot of this occurring or during, I think that's something the plan could take advantage of now and make sure that we're planning for the future, because the future has changed from what it was a year ago. And with respect to planning for efficient and economical use of land and infrastructure, I mean, that would include pedestrian and cycling connectivity throughout the plan area. I think there's no disagreement that that's an intent, but the manner in which it's been laid out is not clear necessarily. And I've identified a new suite of innovative parking standards. That's for the entire KDA. That's not site specific. If we're trying to encourage intensification and transit usage support, then the provincial and the regional plans clearly direct that there should be parking standards that relate to that intensification. In my view, that hasn't been done adequately in the plan. And that would be by promoting the range of housing options, which include some options that may not have any parking, that would certainly reduce vehicular use and ownership and support transit use and the modal split that's set out in the document itself and in the higher level policies. With respect to the reducing vehicular use, I totally am opposed and disagree for this area to the concept of fine grain road system. Because in my view, the fine grain road system introduces vehicles into an area where you're trying to reduce vehicular use. If you have an area where you have a BRT and a transit hub, it makes no sense to me to have a fine grain road system that would bring cars through that area. There should be walking and pedestrian connections, and there should be access for vehicles for those areas that serve the people that are living there. But why, it makes no sense to me to bring traffic from outside the area through these development blocks. So the concept of fine grain road system is something I don't support.
So, Mr. Chair, I just want to point out the witness was just giving traffic evidence, which was contrary to the evidence given by Mr. Chan yesterday, who testified in response to questions from Mr. Kagan that he was not taking issue with the road network in Mr. Kagan's client's quadrant, and I believe he gave the same evidence in response to Mr. Harrington.
So
I just want to have that noted for the record.
Next question.
sorry, Mr. Manette, do you want to respond?
No,
No.
he's not to respond to council.
No. Do you have a response to the suggestion that was just made? Was there something that you wanted to communicate to tribunal based on what Mr. Kussner had indicated?
Yes, that's a mischaracterization of what I just said.
Thank you.
And specifically with respect to Mr. Kagan.
Can we move to page 11 of your witness statement? Paragraph 34. And 35.
Okay, that's consistent with the statement I've made. The secondary plan does not provide a robust vision for transit supportive development, and the zoning bylaw does not provide standards that would reduce the cost of housing, a critical factor in achieving complete community vision as articulated by the region. And, well, I'm not sure how I can clarify. My comment with respect to the fine grain road system does not mean there shouldn't be roads to serve development blocks, especially in new areas. So I don't see, I think that it's important that you would understand that.
Can we go to page 12 and deal with issue 1?
Okay, so issue 1 is, are the secondary plan and zoning bylaw consistent with provincial policy statement? Are the policies of the secondary plan clear, reasonable, and attainable as required by policy 4.7 of the PPS 2014 and the preamble to PPS 2020? My response is no. As currently drafted, the secondary plan and zoning bylaw do not provide clear, reasonable, and attainable policies and or regulations to allow development to proceed on a timely basis to site plan approval. There remains a lack of certainty for existing developed sites, which currently leads to the expectation of a negative planning outcome. And what I mean by that is that the current plan, and this relates to actually phase 1, phase 2, just the concept of that, there are a number of policies that all they do is suggest there be more studies done. And in my opinion, if this is a secondary plan that's coming up with policies that can lead to developments that can proceed to site plan in the shortest time frame possible, there shouldn't be a need for any more studies to develop the policies further. The study should have been done as input to the secondary plan, so that the secondary plan document would have policies and implementation mechanisms that would provide for the earliest development approval process possible without uncertainty.
Issue 2, please.
Do the secondary plan and zoning bylaw conform with the following provincial plans: Oak Ridge's Moraine Conservation Plan and Growth Plan 2019? No, they do not conform, since the area of the secondary plan is located within the settlement area of the Oak Ridge's Moraine Policy Plan and the Growth Plan, both of which require land use policies that actually promote the efficient use of land and infrastructure with transit supportive densities through intensification and redevelopment, including a full range of housing. The introduction of public roads where they are not required is not an efficient use of land. The city currently does not have a parking strategy unless you consider the 2010 parking strategy as the one we should be adhering to. And in my view, that's well out of date. And in fact, that's still in its draft form. And I've dealt with that through many years over the policies along Yonge Street redevelopment. And for the most part, they are not followed. They are done, those applications have always been done through site-specific regulations. And there, in the last part of the policy, which is not redacted, my comment is the use of private roads where they can serve the same purpose as a public road will allow for a full use of a site for underground parking, which is an efficient use of land and allows for creative title stratification arrangements with provision for publicly accessible open space amenity uses above grade. And I think that is the vision that should be coming forward as new planning.
Issue 3, please.
Do the secondary plan and zoning bylaw conform with the requirements for a secondary plan, KDA, and transportation and parking policies of York Region official plan? The proposed secondary plan does not fulfill the requirements of the York Region official plan for preparing a comprehensive secondary plan, and I reference policies 546 and 548 of the regional plan. And just as a general comment, I heard the evidence of Mr. Coe this morning, and I was quite shocked and surprised to hear the role that the region played in the secondary plan process or lack of input process that they had. Because my understanding is that although they may have deferred the approval authority to the staff, and the staff appears to have deferred that to the city, there would still be responsibility as the planning function of the region to ensure that its own requirements for secondary plan approval were met. And I don't believe that Mr. Coe opined that they actually did that exercise.
And you referred to section 5.4.6 of the region's official plan. I have it on screen.
Right.
And can you just walk us through specifically?
Okay. We've highlighted a couple of spots. So it says the comprehensive secondary plans for regional centers and key development areas, which would include this area, prepared by local municipalities and implemented in cooperation from the region and related agencies, these plans shall include. And then I'm looking at B, for example, the establishment, implementation, and or continuation of a fine grain road grid that incorporates sidewalks and bicycle lanes. So there's a fine grain road system proposed, but I'm not sure that at the level that it's at does not identify the incorporation of sidewalks and bicycle lanes. And in fact, I'm not sure that all of the ones identified will be able to accomplish that. And E, a minimum requirement that 35% of new housing units be affordable, offering a range of compact housing forms and tenures, and intrinsically affordable units for low and moderate income households. There are no policies that specifically identify how that can be accomplished. There's just a reference that it talks about it, but doesn't indicate how it can actually be implemented through the secondary plan.
So just hold for 1 second. I want to go to Exhibit 33, tab 19. Exhibit 33, tab 19, page 8. Section 12.2.6. That's the housing policies.
Yes.
Yes. And what's your comment?
Well, the comment specifically is on 12.2.63. We indicated that that policy should be struck because there's no indication of how that can be done. And in 12.2.61, there's an indication that the policy says that the minimum of 35% of new units shall be affordable in order to realize the city and region's housing targets. And we've added to provide housing options that are responsive to the needs of the city's current and future residents, because there's no indication as to how that was going to be done. So we wanted to at least include that there would be options and that respond to current and future residents' needs. So I think it's important to do that.
And
then if we go up to the next page on number 5, we have indicated that we thought there should be an inclusion of new purpose-built rental accommodation will be promoted to address a gap in the supply within the Bernard KDA. So it's clear that that is a direct goal for the secondary plan.
how do you know that there's a gap in supply of rental housing in Richmond Hill?
Because all the reports we've heard from both the region and from the city confirm that.
You also referred to section 5.4.8.
Yes, and that deals more with the parking. So secondary plans and zoning bylaws shall, and we've highlighted the word shall, in consultation with the region and related agencies, incorporate parking management policies and standards that include reducing minimum and maximum parking requirements that reflect the walking distance to transit and complementary uses. Well, you can't get any closer to walking distance to transit than we have in this KDA, because we have both the transit terminal for the buses and the BRT line within walking distance of the almost the entire KDA. So the expectation would be that this is an area that would be ripe for consideration of minimum parking standards and putting a cap on as well in order to promote the public transit. And we've had, through our discussions with the city, they're not prepared to reduce them to a point that we think is appropriate.
I
And that's
have
for
to
the
object,
entire
Mr. Chair.
KDA.
We're now talking about a further reduced parking standards, which we've already established is off limits for this witness's testimony.
He didn't talk about the rate. He just talked about the concept.
Well, the concept is off limits.
And if I go to E, that identified preferential locations for carpooling and car share spaces, and that has not been identified in the secondary plan.
And just a question, it says, and zoning bylaws shall?
Yes, so the
Okay.
zoning bylaw should reflect that as well, obviously.
Is there any provision for carpooling and or car sharing spaces in the zoning bylaw that's being proffered KDA-Y to this tribunal?
No.
And if that's the case, what is your view of the zoning bylaw in that respect?
That those things should be incorporated into it before it's approved
On a KDA-Y basis?
on a KDA-Y basis.
Thank you. And now you want to just continue back to your witness statement, please?
Where did you want
Okay.
to focus?
Paragraph 4. On
Okay.
page 13, paragraph 4, I think we're now moving to the city's official plan in section 5.1.5. I would be grateful, Raj, if you could put that section up on screen because I just don't have it accessible right now. 5.1.5 of the city's official plan, please. Thank you. No problem. Thank you.
Okay, so just so we know that the section 5.1.5 is the section of the official plan that gives us the outline of what is required for the preparation of secondary plans. And as I indicated, that in my view, there was no detailed technical opportunities and constraints analysis undertaken as a basis for the plan. And that would be over the page on page 5.2, that would be policy 5.1.5F. So that clearly requires the opportunities and constraints posed by the unique features or characteristics in the secondary plan area. And I don't think that analysis has been undertaken.
And can we just go back to subsection D? Look on screen.
Right.
Says the proposed development concept for the secondary plan area.
Yes, and I think you've heard some evidence on that through the hearing to date. In my view, there has not been an overall development concept for the secondary plan. There have been, you've had reference to the demonstration plans which were provided, but only provided at the last minute and not in advance of council's approval of the secondary plan. But those were generally prepared to identify how the angular plane matter would be dealt with respect to height. So they were not what I would consider a full development concept, and there certainly was one for the overall plan area. So that was a deficiency as well. And then under G, it says land use policies to ensure compatibility with existing and planned adjacent uses. And there really hasn't been any description of how that's to be done other than dealing with angular plane. So I think that's something that should have been, there should have been more work on that done as well. And as far as location of community uses, I don't think other than, and there's I guess a reference to one of the, I think in one of the emails from regional staff, there was a reference to the consideration of the bus terminal as a community use. The bus terminal is already in place and it's effectively fixed in its location, at least for the time being. But as far as any other community uses, there was no real consideration of that as part of the secondary plan. So I don't think the full requirements of the preparation for a secondary plan within the town's own Part 1 plan have been fulfilled.
Paragraph 5 on page 13.
Should the policies in the secondary plan take precedence over policies in the Part 1 plan? And that's because Chapter 12 would be the location within the official plan Part 1 that you would see the secondary plan. It would be implemented through that process, I expect. And of course, the draft chapter is a chapter within 12. So in my view, the secondary plan usually, from a planning point of view, always has precedence over the Part 1 plan because it's more detailed.
And if we can just take you to our proposed modifications. Do we find that modification 12.1.1? So we're at Exhibit 33, tab 19, section 12.1.1.
And that would be found at the end of the first paragraph, which says, notwithstanding the policies of the secondary plan prevail in the event of a conflict with the policies of the Part 1 plan. And that's a customary sentence or phrase that you usually find in the secondary plans. And it was just, it may have been missed out by just by error or accident, but I think it should be incorporated just for clarity.
Thank you. Next, please.
Do the policies in the secondary plan promote and facilitate intensification and the development of complete communities within the secondary plan area? Do the policies actually promote the efficient use of land and infrastructure with transit supportive densities? Further, do the policies in the secondary plan promote and facilitate an appropriate level of housing options, including the promotion of zero-car households in order to address housing affordability and housing attainability in the city? And my answer is no. Now, with respect to the densities, I think the densities being proposed are reasonable and appropriate, but whether you would ever be able to achieve those based on the other policies which provide constraints to the opportunity to achieve the density would be a problem. Several of the proposed policies work in concert to promote the inefficient use of land by requiring unnecessary public roads, unjustified open space zones that take up developable land, restrictions on underground parking areas and parking standards that increased housing costs and serve only to further exacerbate the housing crisis in Richmond Hill. And I think that's, when I refer to the housing crisis in Richmond Hill, that's a public knowledge statement. I think everybody understands that that is an issue in Richmond Hill and other parts of the area. And now it's interesting, in paragraph 7, it hasn't been redacted, but I would like the direction of the tribunal as to whether I'm supposed to give evidence on that.
Please do, at least the points that aren't.
Because there are some parts that are not redacted, but it refers to the May 13th council meeting.
Just hold for 1 second. So this again, we're in the state of confusion about this redacted witness statement dealing with that paragraph where you've basically removed something that is it's just a council resolution.
Well, this is the actual extract from the council meeting. It's not.
If I can assist, Mr. Chair, the reason for the redaction is, firstly, it relates to a council resolution that's been determined to be irrelevant. But secondly, the substance of the resolution in part relates to matters that are phase 2. So we redacted the matters that relate to phase 2, didn't redact the matters that are properly within phase 1.
Okay, so So we find ourselves again in this,
Yes, I'll explain. We had already ruled that we couldn't consider the May 13th meeting because essentially any decisions made then were rescinded by the new resolution on the 14th.
Yes.
And so we're not looking at the May 13th materials. 13th.
Okay.
sorry.
That's why you can see why I'm confused because it wasn't redacted. Okay.
Okay,
so
So
sorry,
okay.
just before. Thank you. And I appreciate that, Madam Chair. And just for the record, we obviously take issue with that. Okay, go ahead.
And I'm sorry, Madam Chair, I didn't mean to create any confusion on this, but we certainly take no issue if the witness wants to give his own opinion and evidence on the unredacted matters. My point was simply that it should be done in reference to a council resolution because the resolution is a nullity. But the witness is certainly still at liberty to give his opinion on items that the items mentioned in numbers 2 and 3, for example.
Well, thank you for telling
Unredacted,
us
just-
now, because this
it's
has
just-
been part of the
That's why it's
confusion that we've.
unredacted. The unredacted told you that.
have you got a question? to
Oh,
correct
no, I was
the
waiting.
witness?
Oh, sorry,
For
sir.
what?
I was waiting for direction.
No, we were waiting for you to say go. Okay,
Go.
Go.
Jeez.
so Mr. Manette, now we can go back to
So can I
page-
talk about number 2 or not? I just don't know that. Mr. Kustner said I can talk about number 2, but I don't think you did. So I just wanted direction as to whether I
No,
should.
we didn't say you couldn't.
Couldn't.
We agreed that
Okay. 'Cause
In the-
this number,
what's unredacted, you can address.
okay.
But unconnected, if you want to put it that way, with the May 13th meeting.
Okay.
Which
so
is-
it's-
yeah,
all right, so-
go.
So one of the items that's listed is called identify BRT line along Yonge Street and indicate BRT line and associated stations on the legend. I think I've given that evidence before that that's something that should be included because it was missing. Okay. So that shouldn't be contested, I wouldn't think. And the other one is, now this is more important, remove the reference to the ring road system within the KDA. Now, the question is, where is it to be removed from? Because I'm not sure the words appear in the KDA plan, but it's in the staff report. So it may not be necessary.
Well, in fact, they don't appear anywhere.
That's correct.
Right.
So, okay,
I mean, the words don't.
right. But of course, but the reference at the front end was to the staff report. So just to be clear. Okay. Okay, now with respect to the zoning bylaw, there's the unredacted response says, in support of good planning and a positive planning outcome, there is a need to create certainty and allow development to proceed. I guess that's what's left. So in dealing with that, and that relates to the zoning bylaw, I think it's important that the zoning bylaw have certainty, and the policies that direct the bylaw to implement the policy should also have certainty. So in a convoluted way, I think that's what I'm trying to address, what's left to be addressed on that one. So the need for good, in order to have good planning, there has to be certainty, and therefore the regulations that implement the policies should provide for a positive planning outcome by having certainty. I think that's the best way to phrase that.
Okay, now we're now moving to issues specific to the secondary plan. We're on paragraph 8 of page 15. And at the same time, we should be tracking the modifications set out in Exhibit 33, tab 19. So we should have tab 19 open at the same time.
Okay.
And then we'll just, you see the section number, and then you look at tab 19 and you see where the mod and what the response is.
Okay.
Please.
Okay, so the first one is looking at the introduction, purpose, vision, principles in section 12.1. Are the policies contained in this section accurate, coherent, and implementable? And my response is, at the planning level, there is no sufficient description or analysis of the existing character of the area. There is no clear description of existing uses in the area to determine what should be maintained and enhanced, what greater mix of uses is needed or appropriate through new development, and what actual vision is for the future of the area. There is no demonstration plan to test the policies and zoning regulations being proposed. And of course, at that time, there were no demonstration plans. And then the demonstration plans that came forward later didn't really do those things either because they dealt mainly with angular plane and height.
And
We've made recommendations for word changes.
tab 81.
So we've added that we have a settlement area designation in the third paragraph. We've already indicated the policy related to the Part 2 plan, prevailing over the Part 1 plan. The first sentence that says the purpose of the secondary plan is to further articulate policy to guide the evolution of development. We're not talking about the evolution of development. We're just talking about the development. The evolution is something that would have occurred already. And then we just have the identification of Bernard KDA. That's more just make the wording better. Then in the next paragraph that starts furthermore, there's a reference to the settlement area, and then that it provides policy direction to ensure that future development is appropriate and meets the objectives of Section 18 of the Oak Ridges Moraine Plan. And I've struck out for this sensitive environment because there is no evidence that I've seen and no background documentation that would suggest that this KDA is a sensitive environment. There are parts of it on the west side that are in the Greenfield area that have some valley and ravine systems, but those are being incorporated into the plan. But as far as a sensitive environment, I'm not sure what they're referencing, and because it's not defined. So I don't think it's appropriate to have that because that is misleading and suggests that there's some sensitivity that we have to take into account. And then the next, that's just an additional word for clarification. I think it was just a missed word where we put the targeted mix of land uses.
Okay, can we move on to,
The vision.
yep, please.
Okay, so the vision, I've made some suggested changes. The Bernard KDA is envisioned to become we've said second most intensely developed area because the proposed density here, if it was put in place in advance of the Yonge 16th KDA, it would be the second most because the plan so far for the Yonge and 16th would have a lower density than this one is proposed to have. So that's just based on the timing of when this would come forward for accuracy. And so we struck out in the Yonge 16th KDA, and then we're looking at, we want to insert cohesive complete community because we think that's important to the vision, and actively promotes a shift away from automobile use, and not the focus on it, but the actual use itself, where people can work, live, and play. I think that's an important part of a vision. And then we have struck out certain other words and added words. And once again, just for clarity, in accordance with Section 18 of the Oak Ridges Moraine Plan, and that once again, there's a term, sensitive to the environment and natural heritage character of the surrounding areas. There's no document or reference in the secondary plan itself that even indicates that that exists. So I'm not sure where that comes from. And then we have.
Excuse me, Mr. Manette, I've lost where you are. Could you tell me what you're reading from?
Under the paragraph under 12.1.2 vision. I'm just going through our blue recommended changes.
Yeah, okay.
Okay. And I'm going fast because I know that the chair wants us to move as quickly as possible.
Keep going.
If I'm going too fast, let me know. Okay. And then I think it's important to ensure adequate pedestrian space and amenities are there. And once again, there's a term, enhanced natural features, but I don't know what that refers to. And to allow for the integration of low impact development and new development. So I think it's important that we've struck out the words that don't make sense and we've added words for further clarity. And once again, I said at the beginning, my role here is to try and make the plan better and easier to read and implementable. I'm not trying to suggest that the whole thing is wrong. I'm trying to make it better by suggesting changes that I think will enhance the plan or make it easier to follow. And then what else we have? I've got additional on the top of the next page on page 2. We've got the area abutting established residential communities and lands designated neighborhood. I think it's important to identify what that means because the neighborhood is an actual designation that we're adjacent to. And there are policies that relate to that with respect to angular plane and location of angular plane. So I think that should be clarified. Once again, in the next paragraph, second paragraph on that page, I've inserted the term compact mixed use area because I think the term compact is important when we're dealing with an intensification area. And once again, as we go down the page, I've inserted the word new development in a more urban format. And I think that's important because we're talking about a higher intensification area. And then under 12.1.3, we're down into principles. So let's see.
I think you have to keep going with the mods and you'll come back to 12.2 in a second.
Okay. So then under the principles, the term fine grain, we've struck it out here, but I've included that we can keep the term in if we then add the second part, which says walkable street network of private streets and public streets to improve pedestrian and cycling infrastructure. So in fact, as long as the term fine grain includes private streets and public streets, I think that's a workable solution to the concept of fine grain. So I've struck one and added the other. But we can, if you want to keep fine grained in, because then as long as we have the other part, then I'm happy with that, because that was through discussions I've had. 1B, strengthen the connection to existing greenway system. I think it's important that we add where feasible, because there may be areas where it can't be accomplished for the reasons that it's not possible to do it. And then,
are we allowed to, excuse me, I need direction from the chair. Is the witness allowed to cite any examples of what he means of why with respect to feasibility?
I didn't hear the answer. Is that okay? Well, as an example, just where something is fenced and doesn't allow. Sir?
Go ahead. Go ahead.
Okay. So the term where feasible, if there is a restriction of access because there's a fence and it's a hazard land, obviously it's not feasible, so you couldn't do it. Okay. And then it's important that, and I think this has been discussed, and I don't think there's an issue with this, inserting urban plazas and privately owned public accessible spaces known as POPs. I think that's a term that is understood through urban design and also through open space use. And create an enhanced streetscape to frame new development by providing an improved streetscape environment for pedestrian activity and LID, low impact development practice. And that's all I think I have for 12.1.
Thank you. Can we go to paragraph 9 on page 15 of the witness statement that deals with characterizer?
Okay, so character areas is found on page 3 of the secondary plan. So do 12.2 and mix of use section 12.2.1 and related schedules. Does the secondary plan contain appropriate policies for non-residential uses, including density to be allocated to non-residential uses on any individual development site? And the response, it is not clear as to what Yonge Street character is intended to be strengthened or must be created, since there was no actual description of a Yonge Street character. There's no basis for the arbitrary 15% minimum requirement for non-residential gross floor area. There's no basis for the requiring active at-grade frontages along the entire length of Bernard Avenue within the KDA. Nonetheless, and then I guess I'm not going to talk about that because that's a concept site plan matter, and I think it's appropriate to leave that out if I'm okay with that.
And just flipping back, for example, on 12.2.12, there's a couple blue highlights there.
Right. And this is done for clarity to a certain extent. And that's some wording to make the wording proper. So we're subdividing. We've looked at the 15%. We're suggesting it should be reduced to 10%. And we've added live, work, or community uses. That goes on to the next page. And or purpose-built rental and other community uses. I think it's important to introduce the concept of purpose-built rental into the secondary plan. And that's something that we've been trying to promote for some time. And I think it's appropriate here because that is something that Richmond Hill is lacking. And I think there's an opportunity in a secondary plan, especially in intensification area, to incorporate that and make it clear that that's the intent. And then we also have the recommended minimum of 10% gross floor area status. We've reduced that. And together with purpose-built rental and or community uses, So we want to have a percentage related to that to make it clear that purpose-built rental is something that's to be promoted within the secondary plan area by policy. So
10 is dealing with height.
right.
But
Okay, so I'm using the general part of this without referring to the redacted area. So in my view, it's appropriate to regulate height through built form criteria as proposed. And that's an appropriate planning method to regulate height. So that's something I agree with. in the secondary plan.
And if you look at section 12.2.2 on page 4, there are no modifications, correct?
Correct.
So there's no dispute about height.
Yes, but I think it's important to also indicate where we support what's being written, because I think that's clear that that's a good policy as it's written now.
When you say as written now, you mean in pink there, is that right? I'm confusing again. As written now, you mean as proposed?
Okay, I just want to make sure I've got, so I'm referring to the right paragraph. There isn't anything. That's 12.2.2. As it, yes, as it shows here on pink, I have no, if where there's no blue, I agree with it. Okay.
At the moment, it's fairly intense and fairly rapid, so we're going to take a 15-minute break right now, just to clarify some of the timing. Are we anywhere near target?
We're going as
think
fast as we can, sir.
I'm not talking. Mr. Manette comes back on Monday, does he again?
Mr. Minette.
I mean, that was the plan anyway.
Yeah, Mr. Minette does come back on Monday anyway. I think according to the plan, we were supposed to be wrapped up his chief by 3 o'clock. I'm not going to hold my friend to that strict time limit, but obviously we'll need some accommodation on cross-examination as well if he's taking longer in chief.
Okay.
I'm just wondering in terms of the timing, if we're not going to finish his chief until realistically 3:30 or later, I'm wondering whether it makes sense just to defer the start of his cross-examination to Monday. That would give me an opportunity to try to shorten the cross a bit over the weekend, but I'm in your hands on that as to whether you prefer to start him today and keep him in cross over the weekend.
Mr. Chair. Sorry, this is Mr. Cherniak. I just want to note that my first witness is scheduled to begin Monday afternoon.
Right.
And as long as he does not end up in cross-examination for the following week until the 21st.
Yeah. Okay.
That would be my only concern.
Well, okay, well, sort of given the timing, we got another hour,
At least.
Mr. Manette? What do you mean at least?
Well, he's going as fast as he can to take you to the actual mods. It's full plan.
Perhaps we could ask you, Mr. Streisfeld, how much longer do you think you'll be in chief?
At least another hour.
Well, we said another hour. I would take it.
He's going as fast as he can.
You said at least another hour, so we've agreed to at least another hour. Okay, 15 right now.
Thank you, sir.